Thank you. Thank you for having me. Well, I'm very happy that we can discuss the DSA results tonight. It was great publicity looking at today's and yesterday's announcement that Elon Musk is planning to buy Twitter. So this puts oil into the fire and causes the question, how can we interpret these questions and the freedoms on the internet? And perhaps rein in the very large platforms. So I think this is a wake-up call, the fact that Elon Musk wanted to buy Twitter. And I'm very happy that the political sphere has woken up before and has found an agreement. I would have been happy to see this 5 years ago. But as Alexandra explained, it takes a while until this has entered into force, until there's been more research, and then we know more about the new opportunities created by the DSA. Perhaps we'll probably see a few years go by before we have more room for maneuver. But then anything's better than what we had now, looking back at the last 10 or 15 years. So looking at the little regulation there was, platforms and operators and providers could do pretty much what they wanted to do. There was way too little democratic control mechanisms. So many things have been explained from a German perspective. It's very interesting to see that a number of the new mechanisms is something that we've seen before with a number of acts and regulations on the media, on the internet. So we have a number of legal acts, and this has been moved to a European level. And that is great because our users see that they're getting more rights to defend themselves against what is going wrong with the large platforms. But we haven't seen all advantages or benefits there could have been. No, but with our group Netzpolitik, many people turn to us, for example, that feel totally helpless when their account has been blocked or deleted by Twitter and they don't know who to turn to. They can turn to the press, but otherwise nobody seems to react if you ask for your account to be unblocked. For some people, this is a disaster. Others say, okay, well, never mind. For many people, social media are a place for exchanging, for getting in touch with other people. And if your account is blocked, you feel pretty much left out. And it would be a very good thing to have a better way to defend oneself and to raise objections. So this is something very exciting to see. Is it going to take ages until, let's say, the Twitter or YouTube support will get back to you? So we've seen this with other debates like the copyright reform. Of course, companies are not so happy about that, but anything like this, any regulation like this means more more costs, and this doesn't fit in with their business models. I was very happy to hear and to see that researchers and non-governmental organizations can have better access to data. That was not possible before, and I think there will be a number of improvements because of that. And a reality check will show where this goes. At the moment, it's a sword of Damocles. For any researchers who are trying to understand how these algorithms for recommendations work, in what way they go against the general terms and conditions, and what are the legal means, or what are the legal loopholes. As I said, this was one of the highlights.
However, the DSA is not really the basic law, the kind of constitution for the internet, which it has been portrayed as in the debate. Alexandra already said that we don't have a comprehensive ban of personalized advertising, which is what we would have needed, which is would have been urgently needed. And again, we didn't really reach that, but still negative consequences of social media have to do with personalized advertising, have to do with the fact that business models are really based on this kind of practice. They want to motivate people to interact more on social media, to collect even more data, to offer even more personalized advertising. And if we want to combat disinformation and hate speech, then we won't solve that problem if we still allow all that kind of personalized advertising and profiling to happen, even if data cannot be used for generating these profiles anymore. So that's a tiny little step. At least children and young people will no longer be able to see this kind of personalized contents. However, how will mobile phones be able to detect who is looking at a certain website, or whether it is a young person or a child using the tablet or someone else? So how is that being put into practice? Well, let's see. There seems to be an issue with monitoring and with oversight. We have learned from that, and the implementation, well, traffic jam, so to speak, when it came to Ireland, for example, is meant to be overcome by creating a new board and by passing new competences to the European Commission. I think that might help. I think it also makes sense to have a kind of independent agency on EU level. We'll have to see how we can deal with that then on a national level, how supervisory activities or monitoring activities will be distributed. But in the end, it is all about whether implementation can be efficient and effective, and about whether these rules work well and how quickly we can learn from the fact that some rules might not be working that well. So how quickly can we then adapt the rules or extend the rules, adjust? So to go back to my initial words, we don't really have a constitution for the internet or a digital basic law then, but it is a very good first step. Thank you. Thank you. That was a very interesting contribution from you, very interesting insights.